Rahui Katene.
Thank you, Mr. Speaker. I come to this bill as probably one of the very few people in this House who has any experience, admittedly not personal, with the Disputes Tribunal. I venture I am definitely one of the few former lawyers in this House to steer clients away from litigation and towards mediation through the Disputes Tribunal. And I come with a particular preconceived view already formed, and that is that disputes tribunals are fantastic. High praise indeed, but a reflection of the fact that these tribunals are an excellent mechanism for keeping people out of the courts. Unlike other political parties, the Maori Party has no tolerance for the obsession with building up the court docks and prison cells by getting tough on crime. We promote restorative justice systems, and in our actions in this House, the Maori Party has consistently supported legislative changes which increase access to justice. It is our view that any real move towards increased access to justice is a community benefit and warrants our support. In keeping people out of the courts, the key benefit is that it is an approach which is significantly cheaper for claimants, not to mention the long-term costs saved to society. The process is mediated and as a consequence can be more restorative in nature than a court setting. There are no lawyers, so the setting is more accessible and less alienating as a result. Rather than being scared off by the legalistic vocabulary, people can actually understand what is going on. A peculiar concept, I know, but true. Another benefit that we consider to be of high value is the fact that there can be whānau support and/or an advocate to talk on behalf if the claimant is not confident to do it themselves. One of the pieces of information which did not come up during the debate in the House last night is a more comprehensive analysis of who actually uses these tribunals. A survey commissioned by the Ministry of Justice as part of the Tribunal's reform project interviewed some 813 people, both applicants and respondents, who had used the Disputes Tribunal amongst a range of other tribunals. The figures showed that the key users of tribunals were more likely to be European, with underrepresentation of both Maori and Pacifica, to be male, to have income of $50,000 or more, and to be aged 40 to 59 years rather than aged 15 to 29 years. This analysis was very informative in demonstrating some specific issues that clearly need to be addressed in any reform process. Just to test my theory, I went to the Māori Legal Services to gain a flax roots on the ground perspective of how well this all works. In the last 12 months, they've had 3 clients seeking remedies with the Disputes Tribunal. None of these clients knew what the tribunal did or what to do to pursue their complaint there. As a consequence, the services needed to educate them about the tribunal and assist them in writing their application. In the end, however, they were unable to confirm whether or not any of these clients had actually filed their forms, as each of the clients thought that the $100 filing fee was too expensive. There is no current ability to waive that fee at the tribunal. My suspicion is that the tribunal is not well known to Māori people. Perhaps it is not well profiled in Māori communities. I suspect that even the $100 filing fee is a barrier to access to the tribunal as well. The issue I would like to seek further clarification from the Minister is if the changes will increase the filing fees, which will inevitably increase barriers to justice from our community. Also, I note that there is no concerted effort to profile the tribunal to Māori communities and wonder if that will also increase barriers. As other speakers have mentioned, the purpose of the bill is to allow more individual and small business claimants to have access to this hopefully affordable justice forum by enabling a larger number of cases to fall within its jurisdiction. We believe the process could be improved by requiring referral of claimants to community law centres, where appropriate, to assist people in filling out the forms and perhaps gaining better access to law. The process is comparably user-friendly already, comparably in that in relation to trying to deal with the complexities of litigation through the district or high courts. But we in the Maori Party believe the disputes tribunal process could be made even more user-friendly. Given that there are forms to fill out, it would be helpful to have someone to explain the procedures and what needs to go where on the forms. This is where organisations like community law centres come in. We would like to see the court staff routinely referring parties to the community law centres for help with this. While this is done now on an ad hoc basis, it would be a positive mood for it to be a requirement where appropriate. We also believe that the process could be far more Maori friendly. Disputes tribunals offered a mediated process. They can be more restorative. They try to avoid legal language so people can understand what is going on. They can have whānau representation, and it is significantly less expensive than going to court. A tribunal may permit someone to be present at the hearing to assist that party in the presentation of his or her case if it appears to the tribunal to be proper in all the circumstances and the tribunal approves such persons. In approving a representative, the tribunal can also impose conditions to ensure that no other party is substantially disadvantaged. The tribunal can either help the parties to come to their own solution or will determine the dispute. Any ruling it makes is binding and will, if necessary, be enforced by the courts. All of these aspects are a very positive foundation for providing a positive need by which Māori can access dispute procedures other than the formal courts, and it is therefore something we wish to support. Aside from the general context that disputes tribunals offer to the legal environment, the purpose of this bill is ostensibly to increase the maximum claim level. The last time in which the claim levels were set for the tribunal was 1998, and so it makes plain common sense that the relative value of this level has inevitably eroded due to inflation and the rising costs of litigation. Other speakers have canvassed the figures, the increase of the maximum claim to $20,000. But the point that we simply wish to make is that we support the intention that the maximum claim level should be increased in order to restore it to the original level that was set a decade ago. The levels need to be updated to allow more people to use the disputes tribunal. At present, claimants are faced with a choice of reducing the value of their claim, facing increased costs associated with district court proceedings, which may not be a viable option given these costs, or not pursuing their claim. Neither of these options seem viable, hence the reason for this bill. We do need to maintain accessibility and to ensure that the level of protections is relevant and appropriate in order to ensure the groups of New Zealanders affected by this bill will still be able to access the tribunals without unnecessary barriers introduced. Every party to a claim is entitled to attend and be heard, and to our mind, this is the very hallmark of a democratic and fair justice system. However, with some exceptions, no party is entitled to representation unless the tribunal considers it proper to allow it and approves the representative. We want to ensure that the tribunal will continue to operate on its current basis, balancing the required protections for parties against the need to provide simple, cheap and fast access to justice. Finally, the last set of issues that we believe are reflected in this bill is that the legislation will allow more individual and small business claimants to have access to this affordable justice forum by enabling a larger number of cases to fall within its jurisdiction. The bill should be seen in the context of the package of proposals designed to assist small and medium-sized enterprises.
I'm sorry, the member's time has expired.
Thank you.
I call Alan Peachy.